David.
And thank you all for coming. This project grew out of a previous work that I had spent several years looking at how ineffective defamation litigation is in dealing with reputational harms. And as part of that, it really got me thinking about what is it that plaintiffs want when they file a defamation lawsuit. And then what kinds of remedies does the law provide to them? Not surprisingly, when I was doing that work several years ago, I discovered there's a big gap between what someone wants and what the law really can realistically achieve for them. Let me just back up for a little bit, because I know probably many of you have not studied legal remedies, so let me give you a little bit of an overview of how injunctions fit into the kinds of things that are available to plaintiffs. Typically, when a plaintiff files a civil case, they request the kind of remedy that they want, and if they're able to prove liability, the court will order it. And typically there's two major categories of remedies they can get. One is money damages. You ask for money in the form of compensatory damages for bills you've paid, and punitive damages to punish the defendant, make them think twice in the future about doing it. The law calls those legal remedies. Some plaintiffs also ask the court to order the defendant to do something or to stop doing something. And lawyers and judges have called those equitable remedies, because they're more of a balancing of the equities in the case. Is it fair to do it? Plaintiffs are not entitled to those equitable remedies as a matter of right. It's up to the judge to decide whether or not, even if the plaintiff succeeds in proving liability, whether or not to actually order an equitable remedy. An injunction is a type of equitable remedy, which has become quite common in a lot of areas of litigation. So there's a saying among media lawyers that equity will not enjoin a libel, that money damages are the sole and exclusive remedy available to a defamation plaintiff. As I mentioned before, as part of the work I did in a previous project, research has shown that money is not really what defamation plaintiffs want most. There have really been very few studies looking at the motivation of plaintiffs in libel cases. A great study was done by Randall Besançon at the University of Iowa in the 1980s. And his team found that only 20% of plaintiffs who file a defamation lawsuit are doing so in an effort to get money. What they found is that 71% said what they really wanted was vindication. They wanted to be able to say that the speech about them was false. And they wanted the defendant to stop saying it, stop publishing it, stop doing what they were doing. So I looked at that briefly in this prior project. As so many projects get their start, I just dropped a footnote in that article, said plaintiffs are not entitled to injunctive relief. I cited to Rodney Smola, who's a law professor, a dean, and his treatise is pretty much accepted authority, says one of the unwavering precepts. And I thought, well, who am I to challenge an unwavering precept from someone as knowledgeable about the topic as Rodney Smola? And I moved on. But I couldn't get out of my head this thought of, is it really true that, that plaintiffs can't recover injunctive relief? And if that is the rule, should it be the rule? So while it is true that throughout, and so that started this project, and what I discovered that is, while it is true that most judges and throughout most of our nation's history, they've refused to grant injunctive relief in defamation cases, this really started to change in the late 1970s. A growing number of courts, including the highest courts in Ohio, Georgia, Minnesota, and California, had granted or affirmed injunctions in defamation cases. And since the 1990s, as I started looking at the cases, I would describe it as a veritable flood of cases granting injunctions. Of the 51 decisions I was able to find, tracing back over the past 300 years, 40 of those 51 decisions were issued after 1990. And about 80% of those cases involve speech on the internet. So I think the internet may be changing the calculus for courts on this question. So with this project, I set out to answer three questions. First, are injunctions directed at defamatory speech even permissible under the First Amendment? Second, are defamation injunctions permissible under established principles of equity, the kinds of rules that courts have developed for themselves over a long period of time with regard to equitable remedies like injunctions? And third, if some form of injunctive relief is permissible, how should it be structured so that it would be both effective with speech on the internet and compatible with our core free speech principles? So as to my first question, I'll spare you the trip down the rabbit hole that is the prior restraint doctrine, and I'll touch on just a few of the highlights. The first is, those of you who've taken media law will know this case, is that the modern prior restraint doctrine that we refer to today saw its elaboration in 1931 in Neer v. Minnesota, which actually was the very first case in which the Supreme Court struck down a statute on the basis of the First Amendment. And in that case, in Neer, local officials used a public nuisance law, Minnesota law, to charge that the Saturday press was printing defamatory and scurrilous content about them, and they obtained an injunction from the court barring the paper from doing any further publishing unless it could prove to the court that its future publications were not malicious, scandalous, or defamatory. This went all the way up to the Supreme Court. The Supreme Court invalidated the statute, said it cannot stand. Did not use the term prior restraint, but this case became known as a prior restraint case. It's really the first of the, as I said, of the modern development of the doctrine. And the court said that this would lay a permanent restraint upon the publisher, to escape which he must satisfy the court as to the good character of any future publication, and therefore struck it down. The court cautioned that it wasn't establishing a principle that was absolute, that in every single instance where a judge issued an injunction, it would be unconstitutional, but it didn't delineate what the limits were of the doctrine. So in going through and looking at these cases, I think we can identify two characteristics that arise that raise particular concerns when the government acts in such a fashion. And the first is when the government restriction is imposed before speech has been uttered or published. It denies society access to expression that's not yet capable of evaluation. And in fact, it may turn out to be protected speech or beneficial speech. The second concern, and I'll talk more in detail about both of these, the second concern relates to whether the restriction was preceded by a full and final determination that the speech is outside of First Amendment protection. So prior restraints and subsequent punishments. This is the first of the two reasons I said that courts strike down statutes, government actions as prior restraints. The first question when you think about prior restraints is, prior to what? What are we talking about? As with much of the doctrine, there really is no definitive answer to this. Scholars have debated this since 1931, but the consensus appears to be that the doctrine is primarily implicated when a speech restriction is imposed prior to public expression. Once speech has been expressed, whatever the government does after that is characterized as subsequent punishment. This comports with the plain meaning of the words. It was the initial interpretation of the prior restraint doctrine. Why do we care if the government tries to stop speech before it's published? As others have said, the whole point of punishment is to make a speaker think twice before they speak, and for speakers that are going to violate the law, not to speak. So if you make the punishment death for defamation, doesn't matter whether you're imposing it after the fact, it's going to stop people from speaking. And that was some of the criticism of this way of distinguishing the doctrine. However, it does feel qualitatively different to have the government come or a court directly say to you, you cannot speak, as opposed to, if you speak, we'll punish you. Justice Blackmun identified the danger that arises when a government restricts speech prior, before it has been uttered. This is a quote that shows up quite a bit in prior restraint cases. It says, behind the distinction is a theory deeply etched in our law. A free society prefers to punish the few who abuse rights of speech after they break the law than to throttle them and all others beforehand. And then he cites a real practical reason for that, which is it is always difficult to know in advance what an individual will say, and the line between legitimate and illegitimate speech is often so finely drawn that the risks of freewheeling censorship are formidable. So after Neer and several Supreme Court decisions that closely followed Neer, Scholars concluded that any restraint on speech instituted before publication was presumptively unconstitutional as a prior restraint. But more recently, the court has added that the special vice of a prior restraint is that communication will be suppressed before there has been an adequate determination that the speech is unprotected by the First Amendment. So accordingly, for any government restriction to have a chance of being constitutional, it must be preceded by a determination that the speech falls into one of these categories that's amenable to government restriction. Most people know of obscenity, that's a category. Defamatory speech is also one of those categories. Scholars disagree over what it really means for there to be a full and final determination that the speech falls within this category, but they all generally agree that preliminary injunctions, temporary restraining orders are highly suspect. So at the risk of making the prior restraint doctrine seem a lot clearer and more precise than it really is, I developed this four-quadrant chart. It did not make it into the article, but it helped me to think through how the prior restraint doctrine works, or how it should function, at least in the context of injunctions. So this upper left-hand quadrant, this is the worst form of prior restraint. This is a government restraint that occurs prior to publication and prior to a full adjudication. This is a temporary restraining order, a preliminary injunction that's issued before someone has actually expressed their speech. Certainly those kinds of injunctions are going to be unconstitutional. The lower left quadrant is the more complicated prior restraint case, even after full adjudication. So we're down here where there's been a full trial or summary judgment. But because it's happening prior to publication, these kinds of restrictions, these kinds of injunctions are presumptively unconstitutional. And really where we do see these kinds of cases is in the context of obscenity, where the court seems to go a little further than it does in other areas. I'm being overly generous with this upper right-hand quadrant, which are injunctions that are issued post-publication, but before there's been full adjudication. I say likely unconstitutional because the Supreme Court hasn't told us specifically that they are unconstitutional, and perhaps they would find a situation where they would permit it, but there really is very little reason to think that that's likely to happen. I'm interested in this lower right-hand quadrant, which is where there has been full adjudication that the speech is defamatory and the injunction occurs post-publication. And I should note that the Supreme Court has never definitively answered this question. There was a case that came before the court in 2005 involving a lawsuit brought by Johnny Cochran, famous lawyer who represented O.J. Simpson. He represented a client of his law firm was unhappy with the services that one of the lawyers provided, and he wanted his money back. And Cochran's firm said, no, you can't have your money back. So this guy made some signs, some placards, and he stood out front of Cochran's offices, and day after day he'd walk with these signs calling Cochran all these bad names. Cochran brought a case, sought an injunction, did not seek monetary relief, only asked for an injunction. Lower court granted him an injunction and ordered the defendant in this case never to mention Johnny Cochran's name again. That went all the way up to the Supreme Court. Within a week or two after oral argument, Johnny Cochran died, and the Supreme Court decided the case on narrow grounds, did not address the central question that whether or not an injunction would be permissible in that context. So we didn't get a good answer, and perhaps my article wouldn't have gotten written if we had gotten a good answer. Do you guys do questions in the middle, or do you do them at the end? What do you usually do?
Oh, I can do them. I'm in
yeah.
This is just a point of clarification. So when you're talking about a post-publication injunction, you're talking about an injunction that stops the continued publication of something, just for
Yes.
everybody's clear about that.
Yes.
Okay, it stops it from continuing.
Stops from continuing, that's right. Because, well, we'll talk about that later on. Injunction is not necessary if it's a one-shot deal. There isn't going to be at least a belief that it's going to be continuing conduct. So an interesting thing about the no injunction rule is that it isn't only or even predominantly based on constitutional concerns. First Amendment obviously has a lot to say about restrictions on speech. But the rule was widely understood to be a hard and fast rule long before the U.S. Constitution came into existence. For hundreds of years prior to the Constitution, judges and scholars were pointing to the fact that injunctions, even injunctions, permanent injunctions following a full trial, were not a permissible remedy in a defamation action. So I set out to find out why. Why was this rule so widely adopted? And I set out to read every defamation case involving a request for injunctive relief. So here's my little slide on methodology. Lawyers, when I give this presentation, law scholars, they don't care about the methodology, but I know from Kathy, you all care, so I'll tell you, and I'm happy to get into more detail about it. Actually, there were no slides until I talked to Kathy, and I got the eyebrow raised when I said I didn't have slides. So I threw some together this morning. So I started by doing a Boolean proximity search on Westlaw. Westlaw is a database, a proprietary, very expensive database that law schools provide for free to their students to get them addicted to it, and then law firms pay thousands of dollars to access. And it includes hundreds of thousands of cases in the federal courts, in the state courts, at all levels. So I ran this search on Westlaw, and this search, which is a proximity search, the /P is any of those terms, and any of those terms within the same paragraph, and that yielded 1,848 decisions, which even with a research assistant, I couldn't read that many decisions. So we started going through those, and I would say, fortunately, for purposes of doing the analysis that I ended up doing, most of those decisions fell out. They didn't meet my criterion for review, which was that the court had to directly address a party's request for an injunction directed at defamatory speech. These terms show up in all kinds of weird bankruptcy cases. There's a cause of action called slander of title, where someone says something like your house has termites, and then it lowers the value of your house, and when they go to sell their house, it reduces the value. There are these weird old common law doctrines. So after filtering and eliminating the irrelevant decisions, resulted with 235 decisions. And I should note that it's certainly the case that I missed decisions that would be relevant, especially in state trial courts. In a previous article I did that looked at Section 230 of the Communications Decency Act and its application to tort claims online. I had a team of 8 research assistants work for almost 2 years to find all of these cases, and we concluded at the end that there are just many decisions that get issued by state trial courts that never see the light of day. Court issues a decision, it never goes anywhere, it never gets sent to Westlaw, no reporter ever reports on it. And so I'm certain there are cases that didn't make it into my review. And like other studies attempting to empirically examine case law, the exclusion of some of these unpublished decisions may bias the results to the extent that there is a systematic difference between the available and unavailable decisions. So what did I find? In reviewing these cases, I found that courts have relied on a number of rationales for the no injunction rule. So the first is respect for the role of juries in free speech controversies. And this is, I think, the most important reason that American courts initially adopted the no injunction rule. And it grew from the John Peter Zenger case in 1735, in which Zenger was charged with seditious libel for publishing something that criticized the governor, the crown-appointed official who ran the province at the time. And during that time, truth was not a defense to a libel claim. In fact, courts believed that if the matter was true, it was actually more harmful to reputation. People at the lower caste of society shouldn't be criticizing their betters. True or not, if it harms their reputation, it's libel. And the jury in that time period wasn't tasked with interpreting what was said. All their job was determine whether or not this defendant, in fact, published the material in question. And that's how the jury was instructed in the Zenger case. Zenger's lawyer conceded that his client had published the statement at issue, but he implored the jury to stand up against tyranny, that free speech was so important that they needed to take it upon themselves to decide whether or not they think this was a proper case for punishment. And the jury decided no, found him not guilty, cheers all across the courtroom and then across the country, and a lot of Legal historians have attributed the Zenger case as one of the reasons why we have a Sixth Amendment right to a jury trial in the federal Constitution, and also one of the reasons why juries play a central role in defamation cases. Now they make determinations as to truth and falsity. Truth is a defense to a libel claim. They interpret what the meaning of the words are. They really play a very critical role. So the idea was that judges should not have the power to unilaterally censor speech without having a jury decide whether or not it's appropriate. In most jurisdictions, even today, in most jurisdictions, equitable relief, and as I mentioned, injunctions are a form of equitable relief, solely at the discretion of the judge. No, a jury is not at all relevant in a judge's determination of whether or not to grant an injunction. And in fact, if a plaintiff sues and only, as Johnny Cochran did, ask for an injunction, the defendant doesn't have, in some jurisdictions, in many jurisdictions, a right to a jury trial at all. The judge will decide for him or herself whether or not to grant an injunction. So the no injunction rule was a way of ensuring that that power wasn't distilled into one person. Another reason that I found evident in these cases is the law's antipathy toward injunctions is rooted in the long-standing view that legal remedies, these monetary remedies, are preferable to equitable remedies for a couple of reasons. One is that historically there were two different courts to handle these. Equitable claims went into a special court of equity, and they couldn't award money damages. Legal courts, courts of law, could only award money damages. They couldn't award equitable relief. And the judges didn't want to step on each other's turf. In 1938, they were merged in the United States when the Federal Rules of Civil Procedure merged them. And then most states followed within a decade. There are still some distinctions in the UK, any of you who study international law issues, and in other jurisdictions as well. After 1938, this reason has less salience. And I find it less persuasive. But another reason that, that stems from this, that's apart from the different jurisdiction of the courts, is that equitable remedies are typically more burdensome on the court to enforce. So money damages, I order you to pay $1,000. Well, the sheriff can go and seize your car, sell it, and you can get the $1,000 that way. The court doesn't have to do a whole lot. It issues its judgment, and then the judicial process plays out. For equitable remedies, the judge has a role in it. The judge has a role in determining whether or not it's his or her injunction has been followed, and in devising sanctions for those who don't follow it. So it's a much heavier administrative and enforcement burden on judges, and judges tend not to want to have to do that extra work, so they have a preference for money damages, as I mentioned before, those are called legal damages. So related to that burden, courts have refused to grant injunctions because of skepticism about the effectiveness of speech injunctions. They face a very formidable challenge in drafting an injunction that gets at the kind of speech that, that harms a reputation but isn't overly broad. So in the Johnny Cochran case, the court issued an order that said, don't ever mention Johnny Cochran again. Well, that's pretty good, right? There's no way that this person's going to be able to defame Johnny Cochran without mentioning Johnny Cochran's name, although I guess he could describe him in such a way. Hey, that lawyer who represented O.J. Simpson, he's a jerk. That's a statement of opinion, but he robbed me. That would be a statement of fact. And maybe you could get around it that way. But generally speaking, the more effective an injunction is, the more overbroad it is, because it ends up restraining more speech than it's permitted to. I'm going to go through in a minute. I'm going to give you a breakdown of how I've categorized the various junctions. And then judges also face, even if they can craft a good injunction, they face enforcement problems due to a court's limited jurisdiction. A court in North Carolina can't enjoin speech in South Carolina. It can't enjoin speech in New York. And the fact that speech can come across state borders very easily through the internet, through broadcast, judges have these practical limitations on their ability to exercise their power. So, as I mentioned at the beginning, a growing number of courts, however, have been granting or affirming injunctions in defamation cases. I identified 51 decisions, or approximately 22% of the cases I reviewed granted or affirmed an injunction. And while many of these courts did so, a shocking number of them did so without analyzing the First Amendment at all. Those that did have developed a line of reasoning that states that an injunction is permissible if it's issued after a final determination that speech is defamatory. So that bottom right quadrant on my chart, courts have been identifying that area as potential ground for injunctive relief. The Supreme Courts in several states have done that. Some appellate level courts have done that. The lower courts have made a complete mess of that rule. They've been granting preliminary injunctions in TROs before there's been a final determination that the speech is defamatory, and they've been restraining way more speech than is appropriate. In First Amendment parlance, we call this overbreadth. So to get a, oh, those were my, get those. To get the extent of these overbreadth issues, I created a taxonomy to identify the scope of the injunctions that existed in these cases. A number of courts have issued what I've termed type 1 injunctions. These are injunctions that prohibit a party from making any statements about the plaintiff. This was the Johnny Cochran case. And apart from ordering someone not to speak at all, which fortunately did not show up in any of the cases, type 1 injunctions are the broadest and most problematic of the 4 types of injunctions that courts have issued. Because type 1 injunctions invariably restrain speech that has not been adjudged to be defamatory, and even under the broadest reading of defamation law, could never be found to be defamatory. What if Ulysses Torrey, who was the defendant in the Cochran case, had made a statement of what a great job Cochran had done in representing O.J. Simpson? Clearly that's not defamatory, but it would have been a violation of the court's injunction, and therefore the injunction would have been overbroad because it restrained that speech that was not amenable to any sanction at all, let alone an injunction. So no less problematic are type 2 injunctions, which prohibit a party from publishing any defamatory statements about the plaintiff. Why are these problematic? Well, they're overbroad because they're not precise enough, first of all, to put the defendant on notice as to what speech will violate the injunction. Second, as the Supreme Court said in Neer v. Minnesota, which was a type 2 injunction. This was an injunction issued by a court saying, barring the defendant from publishing any information, quote, any publication whatsoever, which is malicious, scandalous, or defamatory newspaper. It's problematic because it puts the judge in the role of perpetual censor. That the judge then rules on a case-by-case, contempt-by-contempt basis whether or not the speech is permitted, and whether it's not, it's a violation of the injunction. And as Chief Justice Hughes stated in the Neer case, this type of injunction is, quote, the essence of censorship. So a type 3 injunction prohibits a party from publishing certain enumerated statements about the plaintiff without limiting the injunction to the specific statements that have been found to be defamatory. The majority of the decisions that I analyzed fell into this category. 29 of the 51 were type 3 injunctions. So a type 3 injunction, for example, might order the defendant to take down an entire website, even though just one page has a defamatory statement on it. Judge may be permitted, assuming that it's after full adjudication, to order the removal of that one defamatory statement, but everything else on the website that hasn't been judged to be defamatory is not appropriate for sanction at all. So type 3 injunctions prohibit broad categories of speech. They often list lots of, every page on a website, or every allegation in the plaintiff's complaint, even though not all those statements have been or can be proven to be defamatory. A type 3 injunction can be more narrow than a type 2 injunction, which is why I make it a type 3, because it's more precise, but it's just as problematic because it's enjoining speech that hasn't been found to be defamatory. So the narrowest of the 4 injunction categories is I call a type 4 injunction. This is an injunction that prohibits further publication or orders the removal of only the specific statements a court or jury has found are defamatory. Because it's limited just to the speech that has fallen into that lower right quadrant on my prior restraint chart, First Amendment would say that's speech that falls within a category that's amenable to government restriction. These injunctions, however, can still be overbroad, and I found this great case that's cited in the paper, but I'm going to tell you about it. It's called Griffiths v. Lubin, and it talks about how even speech that is defamatory in one context might not be defamatory in another, and those of you who have used Usenet, and I know at least Paul probably spent a lot of time on Usenet.
There's no such thing as defamation on Usenet.
That's a good point. Well, so you'll get a kick out of this. Those of you that are too young to have ever known Usenet, Usenet used to be the place on the internet to...
Just think of it as the bad part of Reddit.
Yeah, it was worse. So in Griffiths v. Lubin, the plaintiff succeeded in getting a default judgment. Default judgment is a case where the defendant never appears. So the judge just orders the relief that the plaintiff asks for. Got a default judgment against a commenter who had, among other things, called her a liar. That happens a lot on the internet. And accused her of falsifying her credentials as an Egyptologist in an internet news group. You don't have the credentials you claim to do. You're not the expert you claim you are. You're a liar. The trial court enjoined the defendant from making a number of statements, issued an injunction, a type 4 injunction, limited just to the statements that it had found were defamatory, including stating that the plaintiff is a liar. Doesn't sound like a problem, right? Well, the Minnesota Supreme Court remanded to the lower court to narrow the scope of its injunction, and this is what it said. It said the trial court found that Lubin defamed Griffiths by calling her a liar with respect to Griffiths' posting on an Egyptology news group. As a result, the court enjoined her from saying Griffiths is a liar. But because this provision is not restricted to any particular context, i.e. postings to the Egyptology news group, the injunction has the effect of prohibiting Lubin from calling Griffiths a liar, even if to do so in another context would not be defamatory. For example, the injunction prohibits Lubin from calling Griffiths a liar, even if Griffiths were to say that John F. Kennedy was never president of the United States. So that's a court that gets it. It's a court that understands that context matters for purposes of defamation. So in summary, what I found in reviewing all of these cases was that courts are all over the place. While a growing number of judges do seem to be discarding the no injunction rule, they haven't come up with an alternative rule that incorporates the necessary First Amendment safeguards. So that's what I've tried to do. My proposed solution, in this article I propose that at a minimum these safeguards should include the following requirements. I hate slides with so much text, so I'm sorry for that. First, the injunction must be preceded by a judicial finding that the speech sought to be enjoined is defamatory. Second, the defendant, and I'm going to go into these in more detail. Second, the defendant must be given the opportunity to have a jury decide whether the plaintiff has established all the elements of defamation. As I mentioned before, the plaintiff just seeks equitable relief. Most jurisdictions, no jury. My proposal would change that. The injunction must be narrowly tailored so that it targets only speech that has been found to be defamatory. The scope of the injunction must be limited to speech that relates to matters of private concern. And the plaintiff must demonstrate that money damages are inadequate and an injunction will actually be effective in reducing her harm. So in practical terms, this means that a plaintiff has to prove all of her elements of defamation in order to get it. No preliminary injunctions, no temporary restraining orders, no injunctions based on a mere likelihood of success or other speculative standard. And even in cases that involve, as I said, only a request for injunctive relief, the defendant must have a right to have a jury determine whether or not an injunction is warranted. The narrow tailoring requirement means that plaintiffs typically won't get everything they ask for because the injunction must be limited to the specific statements that a court has found are defamatory. This means no website takedowns. Only specific statements can be targeted. Probably the most controversial part of my proposal is that the injunctions cannot be issued when the speech involves a matter of public concern. There are several reasons for this. First is that speech on issues of public concern is entitled to additional First Amendment protection. Second, the state's interest in providing an injunction is less substantial in those situations. And third, when the court is trying to enjoin speech on a matter of public concern, the injunction is less likely to be effective because the court will be attempting to restrain speech that is of widespread public interest. So the fact is that speech on matters of public concern, as I said, will be more difficult to enjoin, which is why this fifth requirement that it must prove that it to be effective will probably knock out a lot of injunctions. Plaintiffs are going to have to show that money damages are inadequate. That's pretty easy to prove. If someone harms your reputation, it's very hard to turn that into a monetary value that adequately compensates you for the harm, the social harm that is a reputational interest. So a lot of plaintiffs will get that over that hurdle. But it won't be as easy for them to prove that an injunction will actually be effective in reducing their harm. All speech now has digital echoes. Whether it's neighborhood gossip shared on Facebook, archived news articles indexed and searchable through Google, or snippets of broadcast footage redistributed through YouTube. An injunction, in order to be effective now, must restrain speech in multiple mediums in order to be effective. And this requires the plaintiff to be able to identify where that speech is occurring. But most importantly, it requires the court to be able to exercise jurisdiction over all of those speakers. So you post something on your blog, court orders you to take it down, it gets picked up by somebody in California. A court in North Carolina can't order someone to take it down from North Carolina, from California. It doesn't have the power to do that. And because of Section 230 of the Communications Decency Act, which provides broad protections to internet intermediaries such as Google, YouTube, and Facebook, courts cannot enjoin or impose liability on those parties that host, distribute, or otherwise make defamatory speech available. Therefore, an injunction is likely to have its greatest utility where there is a danger of recurrent violation, as Dr. Packer pointed out, but also where the speech has not been widely disseminated. So maybe a situation where someone's standing out in front of an attorney's office with a sign, it could be effective. But if Ulysses Story decided to go online and do that and it got picked up and spread through Twitter, how effective can a court be in stopping that? Not very. So I propose in the article some ways for courts to analyze how widely speech has been distributed and whether it has power over the individual speakers. So I'll leave it there. Thank you for listening, and I'm happy now to take questions. And if that was too long, you can blame Dr. Packer, because I told her my original version of this was 20 minutes, and she said people usually talk for 40. Is that true? Is that true?
But I think it's perfect.
No, is it true that people actually speak for 40 minutes, though?
You did 40, you did 40.
All right, good. Daniel.
Not that we were counting.
I saw some clock watching.
I have one question. I guess it's a clarifying question, perhaps because I'm nowhere near an expert. When you talk about something being a matter of public concern, how do you define that? Is that something the courts would recognize on its face? Is it something have the notions of what's a matter of public versus private concern changed given so much private speech now occurs over public networks and in front of public audiences, such as your Egyptology history?
Right. That's why I conceded this is the most controversial part of my proposed test. For two reasons. One is there's, and Ruth Walden has written, or is currently writing a great paper that looks at how courts are not consistent in deciding what's public concern and what's private concern, because it's very much a fact-based ad hoc analysis. So it's hard to draw guidance from those cases to determine it. The other is that by protecting some speech that we say as public concern speech, we are denigrating private concern speech, and therefore providing less protection to that speech. And there are people who and Ruth has articulated this argument very strongly, that creates a sort of tiered level of speech within our First Amendment jurisprudence that's not wise. It leads us in a bad direction. Clay Calvert has written on that as well, as has Mary Rose. But the fact is and so I'll mention in a minute what guidance the court has given us on doing that. But so my response to Ruth, and Ruth read this earlier draft and gave me those comments, same question you had. My response is that the court has very recently reaffirmed this distinction between public and private speech and made it a central part of its analysis of whether or not a government restriction is constitutional. And the case where this came up most recently is the Snyder v. Phelps case, the case involving the protesters at Matthew Snyder's funeral. This is the Westboro Baptist Church that has very strong feelings about homosexuality, and although this had no relation to the soldier who died, they figured they would get a lot of press coverage, and they did. And they said that the death of soldiers in Iraq and Afghanistan was due to America's willingness to allow homosexuality in the military and more broadly in society. And the plaintiff's parents brought, the deceased soldier's parents brought a intentional infliction of emotional distress claim against the Westboro Baptist Church. And the court in Snyder said that the key determinant of whether or not this tort should be permitted, in other words, whether the government should impose a penalty, is whether the speech is public or private, and found that the church's efforts to engage in this dialogue was a public issue, and therefore the plaintiff couldn't recover for an intentional infliction of emotional distress claim in that case. And this case was decided only 2 years ago. In Snyder v. Phelps, the court says, this is how it defines speech. It says, speech deals with matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest, that is, a subject of general interest and of value and concern to the public. Court said, conversely, speech that is solely in the individual interest of the speaker and its specific audience is not speech on a matter of public concern. That's not terribly helpful. May be easy to identify cases at the extremes. It's not so easy for the cases in the middle. The other reality is with regard to this test. So one is that the Supreme Court reaffirmed in Snyder v. Phelps. This is the direction it's going with regard to the distinction between public and private speech. The other is that it's a distinction that's firmly ingrained in defamation law already. Some states use it to determine whether or not a plaintiff who's a private figure has to prove actual malice. So the Supreme Court has said that public figures and public officials have to prove actual malice to succeed. Private figures, it left the states to determine what standard they wanted to apply, as long as it wasn't strict liability. And some states have said if it's a matter of public concern, they still have to prove actual malice, even if they're a private figure. And also I found in about maybe a third of these cases where the courts had issued injunctions, they had relied on that distinction as well. Courts had, so one case involved a woman who would go to her neighbor's house with a giant sandwich board sign saying that he had raped her, and after a full trial determined that the speech was not true. She had some emotional issues, and the court ordered her to stop doing it. So this is a situation where injunction can be effective, right? She wasn't using the internet to do so. If she stops doing the sign, it isn't likely to get picked up by anybody else. And the court said it's private speech. It only relates to these two individuals. The rest of the community doesn't have an interest in it. Query, however, if that were the mayor or someone who has an important role in the community, maybe that would have been a harder call on public versus private speech. So courts are using this test already. But I agree that it's very problematic because it's so hard to handicap ahead of time whether or not speech falls into one category or the other.
I'm imagining your test, and it sounds like if I say David Ardia is a scuzzbag and you can prove you're not,
Right.
then that's our private speech. But if I could say a lot of UNC professors are scuzzbags and David Ardia happens to be a UNC professor,
Yeah.
that I'm addressing the problem of universal scuzzbagness and just associating you vaguely with this. So your rapist, for example, if she were to protest rape in general and happened to be in front of that
Right.
house,
Right.
she would be protected like Phelps. Because Phelps is not saying this particular dead soldier is gay or
Right.
singled out, but just that soldiers as a whole are suffering because the country has violated God's law.
Yeah, and I think
Am I in the right distinction?
I think the way you've analyzed is exactly right, and I think there's a high likelihood that speakers like Westboro Baptist Church that are smart enough to have lawyers advising on what they're doing. Yeah,
Right.
yeah, absolutely. They're going to take a test like this, and they're going to characterize, frame their speech in such a way to make it most likely that it's going to be determined to be public issue speech. I think that was clearly, so there was some hints to this public private distinction in earlier intentional infliction of emotional distress cases, including one involving Larry Flint, Hustler, and Jerry Falwell. And it could very well be that their message was framed in such a way to make that a compelling argument. The First Amendment is a protection that we as a society benefit from that has unfair, disproportional burdens on some individuals. There's no doubt about that. We have generally erred on the side of protecting speech because we think it achieves other important societal benefits, even when in individual cases it seems terribly unfair. And that's also where this distinction drives from, is where do we think there's greater public benefit to public issue speech. where do we think there's less, and that goes to the state's interest in providing a remedy. And that goes way back to the court's case in Gertz, where it said that private figures didn't have to prove actual malice. And the court's point was a public figure has the ability to use the same channels of communication to correct the record, whereas a private individual can't do that, so more interest in the state in protecting those people's reputations. But someone who already has the megaphone, they can protect themselves. And as I point out in this article, the reason why a public figure generally has access to the public is because their speech is of public interest. So, yeah.
Of your cases, David, how many of them, or what percentage were internet cases?
80%. The total cases? So about 80% of the case. I don't know. I haven't looked at.
Or the number in which they allowed an injunction?
Yeah, about 80%. About 80% of the 51 were internet cases. Overall, I don't know. My guess is that lower than 80%, because the bulk of the cases not granting injunctions are way back prior to the internet. So
is that because they're internet cases? Is that why you think we've seen this explosion? Mini explosion of injunctions?
Yeah, I think a couple of reasons. One is we're seeing an explosion of injunctions brought against defendants who are no longer media or libel law savvy. So I talk about in these type 1 injunction cases where the court says don't say anything about the person anymore. These are cases that are typically default judgments where the defendant has not appeared. So they haven't even made any arguments. They haven't alerted the court that there is a First Amendment, and shockingly so, lots of state court judges don't know what the First Amendment says, at least according to read their opinions. You think they even know there's a Bill of Rights. But even when these individuals are with counsel, they're not making the same intelligent arguments about the no injunction rule and about defamation law, and so. I think there's been an explosion of litigation against non-savvy defendants. I talk about that at the beginning of the article. A study was done. So, there isn't a lot, and those of you who are interested in doing empirical work in this area, there's a huge need for it. The Media Law Resource Center out of New York is really the only organization that every 2 years it does a study of cases that go to trial against media defendants, their members basically. But no one knows how many cases have been filed against individuals, non-media defendants. I did a little bit of that when I was at the Berkman Center and found a huge increase in the number of those cases with the internet. And I point to some other sources. I think that the nature of defamation litigation has changed. That the defendants in these cases are much more likely to be pro se when they are represented, to be not represented by savvy counsel. And I think that's feeding into it. I also think judges are they're not they don't really understand the internet, and they're more than willing to issue these crazy broad injunctions as an effort to make it stop without putting any thought into how it's going to function.
Elizabeth Spainhour, who is do you know Elizabeth?
Yeah.
She's an attorney
At Brooks Pierce?
She had one of these cases in Ohio. It was a radio station that had a defamatory report and then put it on the website. And when the because I went to a class once and she was talking about this case, and so she had the copy of what was on the website. It stayed on the website, and the person sued, and they wanted monetary damages, and they wanted the judge to order the story to be taken off the website. And I don't think it was granted in that case, but I remember being so shocked by that because I thought, well,
yeah.
Anybody who read Near v. Minnesota knows that the remedy is not a prior restraint. So
yeah.
It's really...
Yeah, I mean, I practiced law for all those years and just assumed equity doesn't enjoin a libel. You couldn't do it. It was never a question.
Is it alarming to you? I mean, you throw up your hands and go, oh no, prior restraints.
I think that the test the test that has been articulated by these handful of state Supreme Courts, that's a narrow injunction focused just on speech that has been determined to be defamatory after full adjudication, and I would not put default judgments in that category. But cases where there's actually been analysis by the court on the factual record. I think those are probably appropriate cases for injunctive relief. But that's a small percentage of the 51 cases fall into that type 4. I mean, most of the 29 of those 51 are type 3 injunctions. There's a bunch of these type, how a court could ever think it's constitutional to order someone never to mention Johnny Cochran's name? That went all the way up to the California Supreme Court. California Supreme Court did not grant review of the case, but therefore affirmed the appellate court in California, which affirmed the lower court decision. So that went to the Supreme Court after having gone through the entire California court system with an injunction on the books that said Ulysses Torrey cannot mention Johnny Cochran at all. Not only Ulysses Torrey, but his wife, Ruth Kraft, who was not even a party in the case. The court also enjoined her from mentioning Johnny Cochran, just in case, right?
Philip taught me noted.
So you had a question.
I was just curious, if Westlaw, when you do a study like that, with these terms that you put in it, does it actually bring up the cases themselves, or do you have to, if you want to call the case up, you'd hit another button and the whole case comes up?
Yeah. So it depends on how you set the default settings. The way it's set up initially is it gives you a certain number of terms, words before and after your search terms. So you get a sense of the context of where those are, and then it gives you a list of cases. Yeah, then you can read the whole full version of the case. Yes.
Has that made, that obviously must have altered legal scholarship.
Oh, yeah.
Has it altered, let's say, the Supreme Court lawyers, the Supreme Court, do they use Westlaw in addition to all those cases that are filed, which obviously the lawyers have done all the Westlaw searches? Do they do independent searches?
Oh, yeah, absolutely.
Do they
Absolutely.
reach down more than they used to appellate courts, the state courts, or they just kind of rely on the top one?
Yeah, Mary Rose was a clerk.
Mary Rose Papandreou, who was a law professor at Boston College and incidentally married to David.
Incidentally.
And is teaching at our law school this year, and she clerked for Justice Souter.
But I
on the
just was
Supreme
working
Court.
on a paper about the Supreme Court in media, and actually when Westlaw and Lexis came about, there was a dramatic increase, not so much of citing different cases, because they already were able to do the legal research to find lower court opinions, but they started citing a lot of non-legal sources, because Westlaw also includes databases with newspapers and other kinds of materials that were not as readily accessible. And now, so that was, there have been studies that have chronicled that and detailed that. And most recently, there have been an explosion of scholarship looking at how the internet has changed what the court would cite. So now you see the court doing its own research on factual questions, and it raises a lot of concerns about the sources they're citing. They said these are not things that have been before the lower courts. They have not been aired with experts or through cross-examination, that kind of thing. So it's very interesting what's happening with the databases and the internet.
Well, are law schools still packed up with all kinds of published books? Are they now, if you were starting a new law school, you just get Westlaw, or do you have a library?
I wish we had Ann Kleinfelter. Unfortunately, she was sick and couldn't come.
Law students here.
But we do, right, but there are fewer and fewer books in the library. There's a cost associated with maintaining those, the space on the shelves and in maintaining the subscriptions to get those books. So I think law schools devote less to books, but there are some things that, maybe these two can attest to it. I find sometimes thumbing my way through a book ends up being much more effective for me than looking at a computer screen. Do you guys use the books at all?
They make us go and look and see where the books are.
This is
Like the thing with the
to our
unknown
pages
soldier.
in our dual degree program.
I have never done legal research using an actual book.
I have not either, no. But
I don't think so.
it's not as easy as you would think it would be because everything's digitalized. It's actually much, I find myself spending a lot more time on the digital sources than I would if I just had a book to look through, because you can spend like 3 hours trying to research something on the internet because you're just going through case after case after case because it's all there for you. So I think it's sometimes the problem of there's too much information there for you, which you wouldn't think would be a problem, but.
And Don, this year, all of our graduate students who study media law and our honors students and law students have Westlaw. through our library.
Oh,
Yeah,
so-
and I should say there's a competitor to Westlaw that's run by LexisNexis,
Yeah.
and it has similar coverage. So one of the things I did ask my research assistant to do was to go through all these cases and figure out whether the cases were available on both. Because in a prior empirical study I did, I found that Westlaw had much better coverage, and he's still doing that now to go and confirm and see. But they're supposed to have pretty similar coverage. But for purposes of my research so far, Westlaw has proven to be more comprehensive. Yeah.
So I have a question about jurisdiction, really.
Yeah.
If this large percentage of violation injunctions happens to do with the internet, and if the judge can't very well reach outside the state, or in many cases reach outside the country, I mean, the flow of WikiLeaks and other criticisms like that are, even when I teach my students, they go, well, that's against American law, and I go, well, none of these guys are Americans, and they happen to not be in America at all. So how can you enforce any kind of sort of regularized defamation when the actors are often, and I think this is actually true in the Houston case, not in the same state.
Yeah.
And you're trying to apply state law. Which state? Obviously, the plaintiff is going to attempt to have it filed in her jurisdiction, which may account for the defendant never showing up, because I mean,
That's right.
How could they, and why would they, and it's a cost that they can't afford. So it looks like you have we're talking about to make the legal structure sort of deform itself, but not completely enough.
Right.
Because you're still reliant on a structure that's location dependent, or physical location dependent.
Yep.
Whereas the speech acts, protected or not protected, or defamatory or not defamatory, the ones that are being contested are maybe taking place in 3 or 4 different locations and jurisdictions, and possibly not even non-U.S.
Right.
So what's a plaintiff to do?
Well, so I don't have a good answer for you with regard to how the law is developing in that way, because the law doesn't really have good tools for that kind of multi-state consistency. But what we are seeing with the internet is efforts at creating quasi-governmental regulatory bodies that would enforce these things. So trademark is an example of this. These bodies that have international jurisdiction to adjudicate domain names and things like that. Yeah, right. And these
WIPA is about bringing things together where there's a lot of money in contention.
Right.
And what you're talking about here has no money. And it's also not criminal enough that Interpol is going to care.
Right.
So what you have to do is you can get some kind of relief, monetary or other, or injunction. What if the person's in France?
Yeah, and we have, and you mentioned the Speech Acts, I'm not sure if you're referring to. So Congress in 2010 passed a statute, the acronym is SPEECH, S-P-E-C-H, and it was driven by a libel case brought in the UK against Deborah Ehrenfeld by a Saudi sheikh who she had written in a book about terrorist financing and identified him as giving money to a charity that had been used to finance terrorists. 12 books were sold in the UK, and he sued in the UK, and the UK court said, we'll take jurisdiction of the case. She decided not to appear in the case. She's based in the US. And he won a default judgment, won an award, and when they tried to bring that award in the US to enforce it, where she had assets, people got all up in arms about it. Congress then passed a statute in 2010 that says you cannot enforce a foreign libel judgment in a U.S. federal court unless that jurisdiction has protections for speech commensurate to the First Amendment, and that it has protections for intermediaries similar to what we have under Section 230 of the Communications Decency Act. Basically closed down this, what had been called libel tourism, to look around the world for jurisdictions that were plaintiff-friendly where you could win your case.
The way you might get a Longview, Texas, say, for
yeah, and so there's actually been pushback against that. So the world response to that, Russia was extremely unhappy about that. And because there's a lot of wealthy folks in Russia who'd be more than happy to shut down Western media criticizing them. And one of their proposals was to build into ICANN, the Internet Corporation for Assigned Numbers and Names and Numbers, an arbitration body that would make these kinds of determinations of defamatoriness and not, and then if they make a determination, pull the domain name of the site hosting the material.
That works right now on copyright violators.
And yeah, because copyright, like you said, they have money,
They have
those
money
interests
and they want it, and
advance
they have
it.
a strong
Yeah.
lobbying group that,
Yeah,
I mean, we just saw that with Ken.com.
right.
You know, and all phases of it play out, including his winning in the end.
So
far at the
to get back to your question, Paul, I don't see a mechanism on the horizon to create some consistency across these jurisdictional issues with regard to cases within individual U.S. states. But I do see that there's some effort afoot internationally to draw some ways of enforcing these kinds
It's
of
just the
very
cultural
strict.
practice of defamation.
It's so different as well.
varies from
Yeah,
from
absolutely.
very close country to very close country in Europe. In the U.S., at least, the defamation cases have some similar framework within the state.